everyone. Just because of the schedule and the session caucus start for times, we're going to begin the meeting. Will the Secretary please call the roll?
Chairman Briggs.
Present.
Representatives Donahue.
Designation, yes. Here.
Hanbidge.
Designation.
Hohenstein.
Designation.
Howard. Kenyatta.
Designation.
Kincaid. Mays.
Designation.
Pielli.
Designation.
Rabb. Sanchez. Schusterman. Warren.
Designation.
Williams.
Designation.
Chairman Kaufman.
Here.
Representatives Bonner.
Here.
Ecker.
Designation.
Ham.
Here.
Clunk. Ledbetter.
Designation.
Owlett.
Designation.
Rigby.
Designation.
Rowe.
Designation.
Schemmel. Shalaba.
Having established the presence of a quorum, the committee is in order and we'll proceed with today's business. First on the agenda is House Bill 1849 by Representative Rabb. The chair will recognize Representative Rabb's for brief comments, followed by counsel for an explanation. Representative Rabb, you're in order.
Thank you, Mr. Chairman. Some time ago, you brought this bill up for committee consideration, but I asked something that I've never asked before. I asked the committee to hold my bill, and you graciously did. And I did so because I wanted to do the issue of restorative justice right. And this is an important subject matter, and so subsequent to that request, I asked my esteemed colleague from Allegheny County if she would consider having a hearing in the subcommittee that she chairs on crime and corrections, and she graciously allowed for that to happen. And in the course of that meeting, we listened to folks who were victims. We listened to offenders. We listened to practitioners in the restorative justice space. And I learned so much more than when I had originally introduced the bill. And equally important, my colleagues did as well. And after that process, a number of stakeholders from across the state, from a lot of different vantage points, came together in a very collaborative spirit to make sure that this bill was substantive, that it was nuanced, and that ultimately it created a space for restorative justice to be expanded beyond the places where it's currently practiced and codified in law so that we can help communities heal. We can help victims. We can help folks all across the board. And so it is with that sensibility and in that context that I'm proud to be the author of this bill with a number of co-sponsors, and that this bill has been duly amended to address all of the concerns and expertise of the folks who have come to the table. And so I thank you, Mr. Chairman, for the opportunity to have this come before this esteemed committee.
Thank you, Representative Rabb. Counsel Kolodges, please provide any additional description of House Bill 1849.
Thank you, Mr. Chairman. I would simply note that the bill as drafted would simply allow courts the opportunity to order restorative justice as an option. I would note that there is one amendment. It's a gut and replace amendment, essentially. It's A05231.
Counsel, you're in order on the Rabb amendment A05231.
This amendment would create a new subchapter in Title 42 to provide for restorative justice by allowing but not requiring a district attorney to use restorative justice as a pretrial mechanism for any offense except homicide. It does have a condition that the district attorney, victim, and offender all agree to use that program.
Thank you, Counsel. We'll need a motion to adopt A05231 by Representative Kincaid, seconded by myself, Briggs. Are there any comments on the amendment? Representative Bonner.
Thank you, Mr. Chairman. The amendment and the bill itself introduces the concept of restorative justice into the criminal justice system in Pennsylvania at the state level for the first time to my knowledge. And I commend the sponsor for his ingenuity and creativity for this novel legislation, but I cannot be supportive. It does allow for all criminal charges except criminal homicide to be diverted from the court system. This would include rape, robbery, kidnapping, aggravated assault, drug dealing, burglary, everything except, as I said, criminal homicide. So we will never have a trial or sentencing for any of those type crimes if, in fact, this particular approach is accepted by the district attorney and the victim and the defendant. And instead, we're going to substitute conferences where the parties will come together, hopefully have a meeting of the minds, and then go forward without a formal adjudication of the charges. Although I recognize that the consent of all three parties must be present, I have strong reservations for the following reasons. First of all, the legislation doesn't state what will happen if all parties cannot agree on an acceptable plan. Will the charges be referred back into the criminal justice system for further prosecution? It doesn't state that. Secondly, there is no time frame set forth within the legislation as to when the plan must be agreed to. The legislation does not require the defendant to waive his speedy trial rights. And you have 1 year from the date of the filing of charges to have a disposition. And if the parties cannot timely agree on a plan, then the potential is there that the charges will be dismissed due to violation of the speedy trial rule. The legislation does not address the timing of the plan, when it must be reached, and what happens if a plan cannot be agreed to by the three parties. Thirdly, anytime a crime is committed, the public is deemed a victim of the crime as much as the individual named. And the public has as much right to know and observe the proceedings as anyone else. That's why all criminal cases in the Commonwealth of Pennsylvania are captioned as such. It's the Commonwealth of Pennsylvania versus the defendant, not the victim versus the defendant. And this bill excludes the public from knowing anything about these informal proceedings. The plan of action, what judgment or decision or effectiveness there has been of the district attorney's office. The public should not be excluded from this process. They have the right to observe and monitor every step of this process, every decision, and the reasons for it. Again, the public is much a victim as the actual person, him or herself. The public wants and needs to know that public safety is being protected in the future. They, again, are a victim as much as the actual victim. And the safety of the public has to be protected as much as that of the particular individual. The light of justice must shine in these proceedings as much as it does in the courtroom within the normal course of judicial proceedings. Transparency must be part of our criminal justice system. Fourthly, I am concerned about the level of contact that will develop between the defendant and the victim during these proceedings, and the relationship that may develop, including the information that the defendant will gain about the victim and the contacts that could likely occur outside of the courtroom in the event that these proceedings do not go well. Safety of the victim is a major concern to me with this legislation. I'm also concerned that the victim may feel pressured to accept alternative procedures such as restorative justice if the victim knows the defendant, knows the victim or the defendant's family and friends, or the defendant, him or herself, may be a family member. I have a significant concern about a victim who lives in the same neighborhood or the same household as the defendant and knows the defendant's acquaintances, friends, and family members. I think there could be undue influence upon this particular victim to participate in these proceedings so that the defendant does not truly face justice as we normally encounter it. Sixth, the legislation does not address victimless crimes. What do we do when someone is charged with illegal possession of a firearm, illegal possession of drugs, is charged with a DUI? Just to name a few victimless crimes. It is unclear in this legislation who will speak for the public, particularly when the public is being specifically excluded from these proceedings. My confidence just to give this authority to a district attorney has been shaken over the last years. I have great concern about excluding the public from this process and just giving this decision-making to a district attorney. Seventh, the judge is eliminated altogether from this process. Judges play an important role in protecting the public interest, making sure that plea bargains and diversionary processes are fair and reasonable. We saw that recently occur in the Hunter Biden plea bargain deal, where a federal judge rejected a proposed plea bargain as being too lenient and unfair to the public, and which later resulted in Mr. Biden being convicted on 3 felony gun counts. This legislation excludes the judges altogether from reviewing this particular procedure. In conclusion, I commend the prime sponsor for advancing this novel concept of restorative justice, but in this particular legislation, with the concerns that I have raised, particularly not addressing issues of timeliness, what happens if the plan is not agreed to, excluding the judges from the process, excluding the public from this process, and their right to know that justice and safety of all involved are being addressed. For those reasons, Mr. Chairman, I cannot support the bill.
Thank you. Representative Rabb is asked to be recognized. Representative Rabb.
I appreciate my colleagues' comments. I think many of these issues would have been addressed if you had attended the hearing where these nuances and complexities were addressed. And perhaps you were there, and I apologize if I misspoke. But if you look at page 2, line 4, there's something called community conferences. That's the public. So the public is not excluded at all. And while I appreciate the compliment of novelty, restorative justice practices are ancient. And they are not new to our Commonwealth. In fact, some of the most conservative communities in our Commonwealth already do this outside of the court system. You're familiar with the Mennonite community. This is not new. This is new for our legislature, but this practice is ancient and time-tested. Is this bill perfect? No, which is why anyone on this committee or outside of it can come to the maker of the bill and say, here are constructive criticisms to improve it. And those people who did so in earnest have approached me. And that's why this bill has been significantly amended to make sure that it is robust. Judges are not excluded. Mr. Claudius explicitly said this can only happen with the consent of judges, district attorneys, victims, and defendants. So that's the only way it can happen. And I think that's important to say because your comments suggest otherwise, which would not be correct. The last thing I'd like to say is that we have an opportunity here to double down on something that already works. In a body that consistently prioritizes the concerns of at least certain subsets of victims and the importance of victims' rights, The evidence suggests that the vast majority of victims prefer this approach. I'm not talking about district attorneys. One might think in this body that there's only one district attorney in this Commonwealth. There are a few. But the victims themselves, either because they don't believe that the transgression should go through the court system, or they believe this is a better way to heal, not just for themselves, but for their entire family and community impacted by certain crimes, that this is the appropriate and meaningful way to heal. There is no reference to healing in our statutes. There's no explicit reference to harm reduction in our statutes. But at the end of the day, what we're trying to do here is help whole communities heal. That requires everyone in good faith to come together, and that's what this bill seeks to do.
Thank you, Representative Rabb. We're still on the amendment. I have a list of folks. So if folks want to talk on the amendment or wait till the bill. Representative Schemmel, did you have a comment?
Thank you, Mr. Chair. I'll keep this brief. It's seldom that I disagree with my esteemed colleague and office mate, Representative Bonner, but on this matter I do. I think that restorative justice is a model that has proved effective in other jurisdictions that have used it. In this case, the changes that were made with the pending amendment, I think, made the bill better. There may still be some technical elements that need to be worked out. I'm in favor of moving the bill forward. I think the aims of restorative justice are to return all parties as best as possible to being whole. That includes both victim and offender. So I'm a very strong supporter of this bill as amended. And I do believe that the public is represented, should be represented by the elected official who is the district attorney. Thank you.
Thank you, Representative Schemmel. Representative Williams on the amendment.
I appreciate the opportunity to speak on this and couldn't agree more with much of what I've heard. To be clear, this bill is significant for a number of reasons, not least of which is that what we have does not work and has not worked. Our system as currently practiced has not been effective in restoration of not only individuals, but making whole our communities. In a real sense, Representative Rabb is correct. This is not a novel idea. This goes back to the ancient practices in places like Africa, in places like the First Nations of America. This is something we need to do. Novelty is not an appropriate term for what we're talking about today. We are wise if we learn from the past, and this has worked in past civilizations and orientations. I'll also go as far as to say that there are needs that often go completely unmet by our mainstream punitive justice responses, which are concerned primarily with assigning guilt and then doling out punishment. And so for that and a host of other reasons, I'm supportive of this legislation. Thank you, Mr. Chair.
Thank you, Representative Williams. Representative Kincaid on the amendment.
Thank you, Mr. Chairman. In law school, I read a passage about the role of a prosecutor, and it's always stuck with me to the point where I actually wrote it down. And I think it's relevant here, where it says, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. The responsibility of a public prosecutor differs from that of the usual advocate. His duty is to seek justice, not merely to convict. Such an attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation is to govern impartially, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. The criminal justice system would be a travesty if a prosecutor holding years of someone's life in their hand cared about nothing but notching another victory. I think that is the approach that we always should take to how we approach the criminal justice system. And the reality is that our criminal justice system has taken on a much more punitive approach, and that is not supposed to be the role of our Commonwealth. Our Commonwealth is supposed to seek justice. Restorative justice is a way of seeking justice that far too many victims would actually like to pursue and don't have the option of right now. This is an option. This is not a mandate. This is something that is available to folks. And in the areas that are using restorative justice measures, the desires of the victims are paramount. There is no pressure for them to agree to this. They are given full autonomy to decide whether or not they want to participate. But what we heard in the subcommittee hearing on this topic was from victims who talked about being victimized and not reporting it because they didn't want to see the individuals that were the offenders, that were their abusers, go through the criminal justice system. They had personal relationships with those people. They wanted to be made whole, but they didn't have an option of being made whole because restorative justice measures were not available to them. So their choice was to not report or to report and have their family member, their friend, their community member go through the criminal justice system and potentially damage the community that they felt an obligation to try and keep together. So they hid their victimization to protect their community rather than to address the harm done. And restorative justice gives those people an option to have justice done while also protecting their community, their family, their friends, their neighbors. And I think that that is a really important piece of this. There are a lot of people who do not seek justice right now because they do not have this option. And so what this amendment does is brings into this bill the learned lessons from this hearing that really approach that and make sure that we are taking care of the people who right now are not seeking justice because they do not see justice in our current system. So I would ask for support on this, and I think that we had another subcommittee hearing talking about what actually deters crime, what actually prevents crime, and one of the things that was said was that many offenders are more afraid of their mom than they are of the police, than they are of prosecutors. And what restorative justice does also is brings those people, those community members, those elders, those leaders into the process to hold people accountable for harming their own communities. So mom and grandma and elders are able to say, this is not how we behave. This is not what we do. We can do better and you should do better because you have a responsibility to our community to not cause harm here. And look what you have done and we need you to do better. And we're seeing in many of the places where these kinds of programs are operating that is effective. It is working to help reduce crime because people have a sense of responsibility for their community and that is being explained to them. So I appreciate this amendment. I think this amendment makes this bill very, very good. And I would ask for a yes vote. Thank you.
Thank you, Representative Kincaid. Representative Hohenstein on the amendment.
Thank you, Chair. Justice is the word we're talking about here. And I think what we need to do is not just focus on this new concept of restorative justice, but to recognize that our traditional concept of punitive justice is not in keeping with many of our standards that we hold ourselves out to as a community. And I want to just throw out one example of restorative justice, because if these folks can do it, we can do it. And that is the Truth and Reconciliation Commission from South Africa that addressed many of the harms that had occurred over decades under a repressive regime. And Bishop Desmond Tutu, who effectively ran that commission, had this to say: there's another kind of justice, a restorative justice, which is concerned not so much with punishment as with correcting imbalances, restoring broken relationships, with healing, harmony, and reconciliation. And as the prime sponsor has duly noted, we don't talk about healing or harm reduction in our current system because we refer to it as a penal system. We see it as we see criminal justice as equating with vengeance. And any of us who are people of faith know that vengeance is not something that humans ought to be involved in. It is something for our Creator to recognize whenever anyone dies and is meeting whatever their final reward would be. That is where any punishment for what is done here on earth should occur. What we have to be about as we look to finding a justice system that moves us into the future, that looks to restoring or improving or healing relationships so that we can live better lives as a community in the future, means that we can't simply always be focusing on the sins of the past. We have to be able to recognize that people can change, people can be rehabilitated, they can be the productive citizens that we want everyone to be, and that one of the best ways to do that is to have a definition of justice that looks to that future rather than simply punishes the past.
Thank you, Representative Hohenstein. Representative Kenyatta.
Thank you, Mr. Chairman. First I want to start by thanking the maker of the bill for bringing this forward and for bringing a needed conversation to this committee and ultimately to this body about how, as the gentleman just said from Philadelphia, we achieve justice. But I also want to thank the gentleman from Mercer and Butler County for some very thoughtful observations on this piece of legislation and in the ways in which, in a bipartisan fashion, people have approached this conversation, I think earnestly, and with real questions about how we implement this. Our job as legislators ultimately is to pass the budget, which I think we'll do, but not to just keep the ship floating as it is, but in our time that we're lucky enough to be here, to think about how we can really make Pennsylvania a better place. And when I think about the scope of what this could mean for communities, for victims, for achieving justice, this would be truly transformative. But as I began to grapple with this and understand this and was made smarter by the hearing that was held, a part of what stood out to me and one of the questions I asked was frankly about cost to the Commonwealth and about what this would mean from a fiscal perspective. And one of the things that stuck out from all of the research that have been done here, peer-reviewed research over many decades, frankly, is the correlation that you see in restorative justice practices in bringing down recidivism. When we think about our criminal justice system, I think too often we stop at what happens in any one individual case. But for somebody who represents parts of Philadelphia, and I'm lucky to work with a number of organizations in my district who have spent their entire time, energy, talents on trying to tackle recidivism, which is a huge burden and cost to our system. You think about folks who are committing any number of offenses across the Commonwealth, and you know, I had the privilege of interning with a judge in Philadelphia, Judge Fraser Live. And one of the things she brings up all the time is how frustrating it is to see the same defendants over and over and over again in her courtroom. Some have been incarcerated, some have had probation, there's been a variety of different sentences that have been imposed. But I think we have not, in our current system, been able to meaningfully and hopefully in a way that is sustainable, reduce recidivism. Because when we talk about the public's interest in our criminal justice system, I think one of the interests we have is how much money we invest in a criminal justice system that is not producing the type of justice that the gentleman from Chester County in Philadelphia spoke about so adequately. But also, we have not injected into this conversation costs. And so when I see something that is an option, not a mandate, not a requirement, but an option that has shown in some studies to reduce recidivism by upwards of 14%, that is something worth our time. That is something worth our exploration. And I'm grateful again to this committee and hopefully this broader body continuing to make this legislation better, continuing to think very seriously about some of the things that maybe weren't considered, but ultimately moving forward with a product that will allow our system to have another option, one that has, in a peer-reviewed way, showed to make a real impact. And so with that, I'll be supporting this, and I'm confident that the gentleman from Philadelphia will be open to amendments on the floor to make this an even stronger piece of legislation. So thank you, Mr. Chairman.
Thank you, Representatives. Any other comments or questions? Representative Bonner, and then Chairman Kaufman, and then we're going to do roll call on the amendment.
Thank you. Thank you, Mr. Chairman, for the recognition on the second occasion. I would like to note that I did attend the hearing, and it was very informative, and I thank the gentleman for leading that process. One of the things I did learn in the hearing, Philadelphia has implemented this particular program, and I thought there were a lot of good parts to that program. But the one thing they did that this bill does not, they limited their program to nonviolent offenses. And this particular bill includes violent offenses. And I think that is a major distinction before we allow for a program of this nature to go statewide, that we at least test it in the nonviolent arena before we expand it to violent crimes. Secondly, relative to the judge's role in this particular process, the legislation does not include the role of the judge whatsoever. In fact, under 8962 subsection C, it says consent of all parties. And it names the district attorney and the victim and the defendant, but nowhere is the judge found in this process. So the judge is excluded by not being named in this particular process. And then thirdly, under subsection E, it does provide for confidentiality. And again, in my opinion, the public needs to be involved in the criminal justice system. They need to see what is happening to have confidence that the community is safe and that people have been treated fairly and equally. And again, for those reasons, then I certainly respect the gentleman who has drafted this legislation. I think it does create the opportunity for significant discussion and dialogue. But I would note that this is a much different bill than what Philadelphia has been working with. Again, I'll be a no vote, and again, I thank the gentleman.
Thank you, Representative Kaufman, and then we're going to do a roll call. And we're sharing a microphone.
And my microphone happens to be disconnected for some reason. I'm certain the chairman wouldn't do that on purpose, but I thank the maker of this bill and this amendment. I certainly understand the concept of restorative justice. I believe there is a time and place for that. I also believe in grace. Some of the issues raised about this amendment and legislation by my colleague from Mercer, it is important to note that in nowhere in this bill is the judge part of this process of restorative justice. This is not modeled. We're familiar. Many of us in Pennsylvania are familiar with the ARD program, which involves what many would describe as lower level offenses. In that process, a judge is involved in that process. It is something that I think many would consider successful. This is not modeled after or is not referenced as part of this program, and it involves crimes all the way up to, but I don't believe including murder. And so I think there could be a place for restorative justice and a process in our criminal justice system, as long as it is in our criminal justice system and there is significant oversight. And I appreciate and I agree with many of the comments of my colleague from Mercer County. So with that, I will be opposing the amendment and the bill as it is added.
Thank you. I think the chair, the representative is open to, as he said, comments, conversations regarding possible amendments to address this language a little bit more. But Secretary, please call the roll on Amendment 5321.
Chairman Briggs.
Yes.
Representatives Donahue. Hanbidge. Hohenstein. Howard. Kenyatta. Kincaid. Mays.
Yes.
Pielli. Rab. Sanchez. Schusterman. Warren. Williams. Chairman Kaufman.
No.
Representatives Bonner. Ecker.
Designation, no.
Ham. Clunk. Ledbetter. Allett.
Designation, no.
Rigby.
Designation, no.
Rowe.
Designation, no.
Schemmel. Shalaba. The amendment passes.
The amendment is adopted. Motion to report out House Bill 1849 as amended by Representative Kincaid, second by Representative Hohenstein. We had a pretty robust debate there. Any additional comments on the bill as amended? Possibly just closing comments by Representative Rabb if he's interested.
Thank you, Mr. Chairman. I'll keep it brief. One of the statements that hit hardest to me in the hearing is related to a comment that the chair of the subcommittee referenced, which is about accountability and who we're most afraid of, whether it's your mother, whether it's congregants of the church you attend, your neighbors, whomever. But I heard from a restorative justice practitioner, facilitator, who was imprisoned as a minor, who served many years behind bars for a crime he did indeed commit, for which he sought redemption. And he told me in person to my face in email that the traditional system allows defendants and offenders to not truly face what they have done. It's through the system, but it's not addressing the victim themselves. And he said the hardest thing to do was to face the people who he hurt and come to terms with the awful decisions that he made in his youth, and to look within and to find grace, to find the resilience to do better. And that is a beautiful and important thing that our current court system and criminal legal system does not prioritize. And so when we talk in this body about personal responsibility, when we talk about values that a lot of folks from different backgrounds who may identify as socially conservative, it comes back to personal responsibility. Then in this context, this approach that has been used by a diverse array of communities across our Commonwealth, our nation, and our country, and eras in history, this does that work. And the last thing I'll say is I appreciate all of the responses from my colleagues who have supported or not supported the bill as amended right now. And please know that I am open to continued conversation to further improve this bill. This is a bill that is so much bigger than me, than the city of the first class, I assure you. This is about our Commonwealth and how we can heal together. Thank you, Mr. Chairman.
Thank you, Chairman. Thank you, Representative. Secretary, please call the roll on House Bill 1849 as amended.
Mr. Chairman, motion first to adopt it. I don't believe we
Kincaid
did
motioned, Hohenstein seconded it.
that. Okay. Sorry.
That's okay. I
Chairman.
have a good memory.
Chairman Briggs.
Yes.
Representatives Donahue. Hanbidge. Hohenstein.
Designation, yes.
Howard. Kenyatta. Kincaid. Mays.
Yes.
Pielli. Rab. Sanchez. Schusterman. Warren. Williams. Chairman Kaufman. Representatives Bonner. Ecker.
Designation, no.
Ham. Clunk. Ledbetter. Owlett.
Designation, no.
Rigby.
Designation, no.
Rowe.
Designation, no.
Schemmel. Shalaba. House Bill 1849 as amended passes.
Thank you, Secretary. House Bill 1849 passes and will be reported as amended to the floor. Next on the agenda is, this is going to be the speedy part. Next on the agenda is Senate Bill 186 by Senator Judy Ward. Council, please provide an explanation on Senate Bill 186.
Senate Bill 186 substitutes the phrase child sexual abuse for the phrase child pornography in the Crimes Code and the Prisons and Probation Code. This was a recommendation of the Child Pornography Task Force. Essentially, child pornography is an outdated term.
Thank you, Council.
There are no amendments.
Thank you, Council. Motion to report out Senate Bill 186 by, I'll make that motion, seconded by Representative Kaufman. Representative Clunk on the bill.
Thank you, Mr. Chairman, and thank you for bringing up this bill. I want to thank Senator Judy Ward and Senator Judy Schwenk for putting this bill together. They served also on the task force against child pornography here in Pennsylvania. I served on that along with my colleague, Representative Hanbidge, and this is one of the recommendations that came out of that task force. I have the bill here in the House that would do the same thing, so I am incredibly supportive of this. We need to describe this abuse for what it is. It is child sexual abuse. This is not pornography. This is disgusting abuse to our children, and we need to say that here in our statutes. I commend the maker of this, and I thank the chair for bringing up this bill. Thank you.
Thank you, Representative. Any other comments or questions on the bill? Are there any negative votes on the bill? Seeing none, if the Secretary could record it as a unanimous vote, it will be reported as committed. Next on the agenda is Senate Bill 187 by Senator Judy Ward. Council, please provide a brief explanation on Senate Bill 187.
This bill substitutes the phrase child sexual abuse for child pornography in the Child Internet Protection Act. Also, it was a recommendation of the Child Pornography Task Force, same as 186. There are no amendments.
Motion to report out Senate Bill 187 by Representative Hanbidge, seconded by Representative Clunk. Are there any comments on the bill? Are there any negative votes on the bill? Seeing none, if the secretary could please record that as a unanimous vote on Senate Bill 187, and will be reported as committed. Next, under any other business, we will be taking up Senate Bill 1231 by Senator Lisa Baker. Council, please provide a description of Senate Bill 1231.
Thank you, Mr. Chairman. Senate Bill 1231 amends Title 20 by adding numerous definitions of which are applicable to trust generally. It also adds a subchapter known as the Directed Trust Act. This is actually a follow-up to an advisory committee of the Joint State Government Commission, which in 2021 released a report which included many provisions in this bill. This bill allows trusts to be drafted to allow certain powers and duties of a trust to be placed with the trust director. It comes up often. It would allow a trustee to have someone who knows the financial world a bit better than the trustee sometimes to make some decisions related to investments. It also adds a streamlined non-judicial method for settling trust accounts, so there can be a non-judicial settlement of account without going through the court in certain circumstances. There are no amendments.
Thank you, Council. Chairman Kaufman will be making the motion. I will be seconding the motion. Are there any comments or questions on Senate Bill 1231? Before we go to a vote, I do want to just mention Representative Ecker and I are on the advisory committee, the Descendants Estate Law Advisory Committee under the Joint Government, State Government Task Force. And this was a recommendation back in 2020, I believe. The Senate took action on this bill in a very large, with other things, passed 49-0 last session. This session, we broke it up into pieces, and this is the second part of that bill. Highly recommended by the task force, and encourage all members to vote in the affirmative. Are there any negative votes on the bill? Seeing none, if the secretary could please report it as unanimous vote, and it will be reported as committed. Last on the agenda is Senate Bill 1236 by Senator Laughlin. Council, please provide a description of Senate Bill 1236.
Thank you, Mr. Chairman. Senate Bill 1236 actually amends the Landlord-Tenant Act to define tenant. It defines tenant as a person who occupies the land or premises of another in subordination to the other's title and with the owner's express or implied consent, which is included but not limited to oral or written leases or accepting rent by an owner or the owner's agent. It makes other technical amendments in the Landlord-Tenant Act to reflect that as well, and provides specifically that the Landlord-Tenant Act does not apply to a person who is not or ever was a tenant. There are no amendments to the bill.
Thank you, Council. Chairman Kaufman moves Senate Bill 1236. I will provide the second. Are there any comments on Senate Bill 1236? Seeing none, are there any negative votes on 1236? Seeing none, Senate Bill 1236 should be reported as unanimously supported by the committee. Thank you, members. This meeting is adjourned.